Welcome to the LL.B Guide, your compete companion for law students. Let's explore the world where law meets learning.
Jurisprudence is the study of the theory and philosophy of law, encompassing its principles, nature, and purpose. Its definition varies, but it broadly involves the systematic arrangement of legal rules and the fundamental concepts that underpin them. The nature of law is that it provides a guide for acceptable behavior, establishes standards, and can be expressed as legislation, custom, or other rules enforced by a state authority. Kinds of law include substantive law, which defines rights and duties, and procedural law, which outlines the steps for enforcing them, alongside other categories like civil, criminal, and constitutional law. Definition of law in jurisprudence. 1. Formal science. Sir Holland defines it as the formal science of positive law, dealing with concepts like property and contract. 2. Science of justice. Others, like Beale, define it as the science of justice. Nature of law. 1. A guide for behavior. Law sets a minimum standard of conduct that society will not tolerate being violated, such as preventing physical injury to others. 2. A system of rules. It is a set of principles and regulations established by an authority and enforceable by the state, whether through legislation or custom. And 3. A tool for justice. It aims to regulate external human conduct and ensure justice and order within a state and society, as defined in the definition by Ulpian. Kinds of law. 1. Substantive versus procedural. Substantive law defines rights, duties, and crimes, while procedural law provides the rules for enforcing those rights and duties, e.g., criminal procedure. 2. Public versus private. Public law governs the relationship between the state and individuals, e.g., constitutional, administrative, while private law governs relationships between individuals, e.g., contract, torts. 3. Civil versus criminal. Civil law deals with disputes between individuals, while criminal law deals with acts considered harmful to society as a whole. 4. Permissive versus directive. Permissive laws grant rights or allow certain actions, whereas directive laws command or mandate specific actions. And 5. Other kinds. This includes a vast array of specific laws, such as constitutional law, administrative law, international law, and customary law.
Keep learning, keep growing with the LL.B Guide. Don't forget to subscribe and explore more lessons in law.